I'm Dan Clarke. Thanks for joining me. I'm the president here at InterEdge. InterEdge is the company that brought you Truyo in collaboration with Intel. Truyo is used by many clients, reaching well over 1 billion consumers at this point, and that's where I get my perspective on the privacy market. Truyo is used to automate your privacy compliance. What we're going to talk about today is what's on everybody's mind, what's real in CCPA, i.e., what kind of enforcement actions are we seeing, and what can we do to avoid this, at least in the short term? The thing that's driving the Attorney General in their enforcement priorities is always around consumer complaints. The heart of CCPA is always consumers. It's a consumer protection law, and the Attorney General very much views it that way. So you got to keep track of those consumer complaints that you're getting about your business. If you have any of those, there's a complaint form that's live on the Attorney General's site. It's been up for quite a long time, and tens of thousands of complaints have been registered. Unfortunately, you can't see what those complaints are until you actually get a warning letter. So what can you do? Well, keep an eye on social media, especially Twitter. And that actually came from the Attorney General in one of the warning letters. Is Twitter in particular is a good way for you to keep track of what your consumers are saying about you. And the implication is that that's a good proxy for the complaints that are being registered with the Attorney General. Overall speculation on the Attorney General's priorities hasn't really changed that much since Stacy Shessler, who's the managing Deputy Attorney General in the Attorney General's office for CCPA enforcement. Stacy did a webinar a while ago and talked about what the priorities are. And I don't think it's really changed from a broad perspective. It always tends to come back to those rights around do not sell in particular, and the other rights to a lesser degree. But the big thing that they seem to be focused on is do not sell. So Stacy Shessler told us that yes, we're going to do our best to protect underrepresented communities, especially minorities. So they may take particular attention to that. They're certainly going to look at that consumer complaint numbers that we mentioned already, and the proxy around Twitter in particular. But in general, they're going to look for things that they can enforce pretty easily. Jump on your website and start looking around, start probing around. You might do this yourself to your own website. Jump on the website and say to yourself, how easy is it for me to find your privacy policy? How easy is it for me to tell that your privacy policy has been updated for CCPA? Because that's one of the things they're going to look for. If you're on this, listening to this webinar, I'm sure you've updated your privacy policy, but how easy is that to tell? Because things that are easy for them to detect are going to be easy for them to create enforcement actions around. How easy is it for them to do a do not sell, or for them to see an unambiguous and clear statement from you that says, I don't sell data? Because that's what they're looking for. They're either looking for you to say something like, I don't sell data, it doesn't apply to me, or have a do not sell link up and make that prominent and easy to use. And there are risks of not putting up anything or putting up that unambiguous and clear statement. We'll talk about that a little bit. And then the third thing they're looking for is it easy for a consumer to exercise his or her rights? That is, can they submit a request? Can they say, hey, I want to see my data, I want to delete my data? Even if you have an exemption to that, even if you have partial exemptions to that, you always want to make it really easy for the consumer to make those requests to you. And I don't think those priorities are going to change anytime in the short term. So what are they enforcing right now? Well, in the first actions that went out right on the first enforcement date, July 1st, and we'll talk about a couple of those that we've seen, but those first enforcement actions, they actually couldn't enforce the regulations. They could only enforce the statute. And that's because the regulations, although we know they were pretty well finalized in March, they didn't get submitted to the OAL, they didn't get approved until well after those first round of warning letters went out. So they weren't actually trying to enforce the details of the regulations under CCPA, but rather the broad strokes that are captured in the statute itself. Again, that makes you lend back to what's the most obvious, what's the most conspicuous, what's the easiest for them to make stick. And those are those obvious elements on somebody's website. We actually got a further update to the regulations. Those are not the law yet and unenforceable at this point, probably won't be until after CPRA. But those regulations do become very important in how you operate, but that's not what they were enforcing right out of the box. What they were really focused on is what they seem to see as the core of CCPA is that do not sell right of California consumers. So do not sell. The definition of what is a sale under CCPA is very broad, and it's deliberately very broad. It wasn't narrowed by the regulations very much. And I think there's a risk for any company that says, I don't sell data at all. What about those third-party cookies that you're using? What about when you're sharing data with other parties? What constitutes remuneration? Things like Google Analytics. Is that a sale? You're allowing them to see data and use data in exchange for a service. I'm not saying it is. I'm not saying it isn't. I'm saying there's a risk in not putting up a do not sell button. And that's the place where they're focused right now. They want to see either a do not sell button up, and many of us do clearly fit into that definition, or they want to see an unambiguous statement that says, I don't sell data. And we'll talk in a minute about why they want that statement in place and why there's a big risk associated with that. So the bulk of the actions that we've seen so far, and I'm aware of 3 of them so far, they all went to what I would call larger companies, not super giant companies, but large companies. And all 3 of those were really egregious ignoring of CCPA. If you went to the site before they got this warning letter and you looked at it, it was very difficult to find the privacy policy. There were certainly no rights that were displayed or easy to access. And in particular, the privacy policy hadn't even been updated since CCPA became effective. So it was pretty obvious to be out of date. There was no do not sell, nor were there unambiguous statements that they didn't sell data. There was just nothing. There was no ability to exercise your rights, or if there were, it was very, very hidden. And so these cases are pretty simple and pretty clear. And I think in most of these cases, they worked out with the companies pretty quickly. Hey, we just want you to become compliant. We want you to change this. At least one of the sites, which is a popular publisher, has completely changed the way they present their privacy policy. It's very obvious now. It's very conspicuous. They've updated their notice. It's easy to submit a request, and they have a do not sell link up. And I think it was very, very clear in their case that their business model was based around selling data. So many of these actions were around really egregious cases. But there's another one that we're aware of, which is a little bit different, and it required a little bit more probing on their part. In fact, it started off really with the same thing. It said, you don't have a do not sell link up, and we think you sell data. In the case of the other companies of which I'm aware, they actually did sell data, or they came to that conclusion pretty quickly that they probably met that definition. In this company's case, they really felt like they don't sell data, and they really felt like they were going to defend themselves. And so their legal counsel actually went back to the Attorney General and said, nope, we don't sell data. And so the Attorney General then focused on the difference between a service provider and a third party. So you have to understand under CCPA, what is a third party versus what is a service provider? And if you've defined everybody as a service provider, and there's a lot of pressure to do that, then you may not meet the definition of sale, or at least it's not as clear, and it's much more defensible. But to do that, you have to have good contracts in place with those service providers with clear obligations that they have to meet, and then they have to be put into practice. And the Attorney General went a step further, and they actually probed this a little bit, and they figured out from at least some of the service providers that yes, we were under contract. Yes, we are under these obligations. And so probably does fit. Why are they so focused on do not sell and this risk of saying you don't sell data? How does that really unfold for you? It depends from company to company. If you clearly sell data, put up a do not sell link. And yes, it's going to create requests. Yes, it's going to create a workload for you. But you have to do it. I think if you feel like you don't sell data, and you want to maybe take a little bit of risk, but you want to take that position by having a clear and unambiguous statement that you do not sell data and publishing that, it could open you up to private right of action or the action from the Attorney General as a deceptive business practice. And I think that's why they're saying either have a do not sell link up or have a clear and unambiguous statement, I don't sell data. And that's a risk if you feel that you don't meet the definition of sale. You have to consider and weigh the risks of not having a link up. If it's deemed later that you should have had a do not sell link up, then the entire time when you didn't have a link up, that would be deemed as an opt-out by your consumer. So there's some definite risks around not having a do not sell link. On the other hand, I think there's some real power if you can defend yourself and not have a do not sell link up and have that clear and unambiguous position. CPRA just passed. Not a surprise, but it gives us more to deal with. How is that going to change enforcement? In the short term, it's probably not going to change enforcement at all. But when that new agency takes over, most likely on July 1st of next year, I think you'll see a big shift. That agency is well funded, $5 million in the first year, $10 million or more each year after that, with the sole purpose of enforcing privacy legislation in California. They take over rulemaking authority. They take over the ability to take actions. And I think they're going to be much more aggressive and much more in the details. But we have until July until they take over. So we've talked quite a bit about how the Attorney General is likely to really pursue the simpler cases, the easy ones to find when you land on somebody's website. But is it possible they're going to pursue a deep dive in any case? It's always possible. Certainly over time, I'm sure they're going to dive in deep someplace. It's much more likely they're going to go after those easy wins and good press releases, places that it's really very difficult to argue with. However, if they do decide to dive deep into some cases, what do you think those will look like? I think this is much more difficult to speculate on than on the more general case, but I think there's a couple of places where we do get some hints. One of those is around the 30-day notice. The 30-day notice is written very carefully in the warning letters, at least the ones that I've been able to see. It's very, very carefully worded. It doesn't say that you've got 30 days to cure very clearly like that. It says they won't take further action for 30 days. And I think it's written that way on purpose. Why is it written that way? Well, probably because if you're cooperative, then they probably won't pursue anything further against you. That's really what they're looking for. However, if you're not cooperative, they might be able to still look back in that period prior to the 30-day notice or during the 30-day notice even, because how do you cure some of these items? Like in the case of a breach, you might have a cure period in a contract related to a breach, but how do you cure a breach? How do you undo giving away somebody's data accidentally in the case of a breach? How do you do that in certain of these cases too? How do you provide somebody's data when they were asked to, or how do you give it to them in a timely fashion after the fact? So I think that very carefully written phrase that they use around the 30-day period is something that they could use later in an action if they found somebody who's not cooperative. And when it comes to cooperation, I think that's the number one thing that they're looking for is if you get a notice, are you contacting them? Are you talking to them? Are you trying to rectify whatever elements they are? Or, as in one case that we've talked about, explain that you've already have complied and that you really are okay already. But being collaborative and going back to them that way, I think is something they're going to look at very carefully. If you're not collaborative, if you're not working with the office, I think they could easily decide to take further action, especially if you continue to get consumer complaints. And I think that's where they're going to take a very deep dive. And they're going to look especially at all the elements of the operating elements of the regulations. This could really require a lot of effort on your part to defend yourself, even if you're really okay. I think they'll also tend to go after the bigger company more so than the smaller company, but I really think it's going to come down more to cooperation than anything. Could they go after a specific segment? This has been alleged. In fact, there's likely to be a free speech question raised in court, and I think that will probably play out over time, that they're unfairly targeting ad companies and trying to restrict free speech in the case of targeting behavioral advertising companies. I don't think that's a very strong argument. I'm not really sure that they're targeting ad companies. I think they're more targeting do not sell, irrespective of the type of company it is. But I think that's a place that may actually have to play out in the courts over time. My advice, if you do get a warning letter, collaborate with the Attorney General's office. Probably will be better in the long run. One other place we could talk about a little bit is in regards to the pandemic that we're all experiencing today. Everybody knows we're in the middle of a pandemic, and everyone knows that you now have kind of special rights to be able to take people's temperatures, to ask them medical questions. And that's probably a good idea in most cases. It probably is something that can really help slow the spread of COVID. And it's generally a good idea and a good practice. In fact, we here at Trio, on the request of Intel, took the Trio platform and actually applied it to a kiosk that takes people's temperatures and asks them those sensitive medical questions, combines the information together to allow access to a building or not. And we were approached about that because of the compliance elements of it. So you might think that today, well, I don't really have to worry about compliance when it comes to COVID. And I think there's very, very unlikely that any state or federal agency or even local agency is going to end up pursuing anything in the short term related to this. I think it would be very unpopular for even the plaintiff's attorney to pursue something in the short term. However, what happens is later, after the crisis has passed, a couple of years from now, plaintiff's attorneys tend to have very long memories, and they look back, and you could easily face something in the future related to the way you handled data during this pandemic. You're very unlikely to face that today, but it is possible in the future that a plaintiff's attorney could go after you for this. So I just remind you of what your obligations are here. You do have special permission right now to take people's temperatures, ask medical questions. Often this is the first time that companies have done or are pursuing this type of sensitive medical information, but it doesn't exempt you from the privacy and other compliance obligations that you have. In particular, in California, you need to store that information and care for it as sensitive medical information. It needs to be stored and contained separately from a person's normal personnel file. It means you need to keep special permissions around it and special access around it. And you need to be careful with that data. You might be tempted to just purge it all and just get rid of it as fast as you can, but that also carries risks associated with it. What if you're asked to do contact tracing? What if you end up with a case perhaps prompted by OSHA, where the general OSHA retention period of data is very, very long, to a point where you might end up with a conflict. Should you keep this data? Should you not keep this data? We tend to take an approach where we store the information very carefully with redactable certificates and high degrees of permissioning and security, but we do store that information we do comply with all the privacy laws around it. And that's what I would encourage you to do. You have to look at those risk trade-offs of keeping that information versus not. But I think it's probably going to lean more towards keeping the information, even in the midst of this pandemic. Probably won't have any problems with it either way in the short term, but plaintiffs' attorneys, by golly, they might go after you later, and you should keep that in mind as you take special precautions around sensitive medical information. So, in conclusion, in the short term, Attorney General does seem to be focused on do not sell. They seem to be focused on egregious violations, simple things that are simple for them to get on your site and validate. So what can you do about it? Make sure you have an updated privacy policy that's easy to find and easy to see that it's been updated. Put a date on it. Make sure it says updated for CCPA. Have an easy mechanism that's prominent, easy to find, to request information, to exercise those rights under CCPA. And if do not sell applies to you, make sure you have a prominent button that's available and it's easy for consumers to find. If you fit in this category of I don't sell data and I've created this because, or largely because I have service providers and only service providers, then make sure that those service provider delineations are very clear and that their obligations are contractually documented and put in place by your service providers. And remember, with CPRA, the definition changes. It doesn't matter if it's a service provider or not. It matters if you're sharing the data. Thanks for joining me. If you need any help in your compliance, especially in automating your compliance to privacy, you can always turn to Trio.